Today we will be looking at the European Union. The aftermath of World War II saw the creation of many organisations seeking to improve international relations. For example, the United Nations was established in 1945, the General Agreement on Trade and Tariffs, or GATT, and subsequently the World Trade Organization was created to promote trade and commerce between states. And the Council of Europe, established in 1949, sought to ensure respect for human rights through the adoption of the European Convention on Human Rights in 1952. The countries of Western Europe in particular realized the need for transnational cooperation between them. This was not only to avoid future wars, but also to ensure Western Europe's economic and political future in a post-World War II world dominated by the United States and the Union of the Soviet Socialist Republics, the USSR. The later arrival of Japan as a major economic power only served to confirm this view, and it was in this global environment that the first steps towards the establishment of the European Union were taken. So what is the European Union? The EU, our European Union, is a unique organisation that does not quite seek to create a federation of states like the United States, but yet, as regards the scope and depth of the integration that it promotes, goes much further than a typical international organisation. We can describe it as a hybrid organisation, part intergovernmental and part federal. Membership requires states to surrender part of their sovereignty to the EU's institutions, in those areas coming within the EU's remit. In these areas, European Union law is given supremacy over national law provisions. This transfer of sovereignty is reinforced by the fact that many decisions adopted by the member states at European Union level may be adopted by way of what is referred to as qualified majority voting, also called QMV. Thus, laws can be adopted even if some member states object to the adoption of the law in question. Under QMV, directives establishing the internal market can be adopted where 55% of the Council's members, representing 65% of the Union's population, are in favour of the proposal. However, in sensitive areas such as tax harmonisation and foreign policy, unanimity between the member states is required. Thus, in these areas, member states are said to enjoy a right of veto as regards the adoption of policy and law at European Union level. Now, let's take a look at the key treaties establishing the European Union. The European Union has been created through the adoption of different treaties, each one reinforcing and extending the level and scope of integration between its member states. The first European Union treaty was the European Coal and Steel Treaty in 1951, which clearly predates the European Union. The first treaty promoting European integration was the European Coal and Steel Treaty signed in 1951. It established the European Coal and Steel Community, the ECSC, and came into effect in 1952, lasting for a period of 50 years. The aim of the European Coal and Steel Treaty was to prevent war occurring between its member states, namely Germany, France, Italy, and the Benelux countries of Belgium, Netherlands, and Luxembourg. The treaty, which had a lifespan of 50 years, came to an end in 2002. However, it remains significant as it sowed the seeds for future European integration. The next European treaty of importance was the European Economic Community Treaty in 1957. The European Economic Community Treaty was signed in 1957 and established the European Economic Community, the EEC, later referred to as the European Community, or EC, before being incorporated into the newly created European Union in 1992 under the Maastricht Treaty. The EC continued to exist as an integral part of the European Union up until 2009, when the EC Treaty was replaced by the Treaty on the Functioning of the European Union, the TFEU, at which time the EC ceased to exist. One of the main aims of the EC, and now the EU, is to establish a single market, also referred to as an internal market, between its 28 member states, whereby goods, services, workers and capital can freely circulate. After the EEC Treaty was adopted in 1957, promoting economic integration between its member states, we had to wait until 1986, nearly 30 years later, for the next European Treaty, which was the Single European Act. The SEA was introduced to improve the functioning of the EEC, and to do this, it sought to achieve three main aims. The first was to accelerate the creation of the single market. The second was to increase the role of the European Parliament so as to make it more democratic. And finally, it sought to formalise certain practices that had grown up between member states since 1957. For example, by creating an official framework promoting member state cooperation in the area of foreign policy. To some extent, the SEA was the bridge between the economic integration established by the EEC Treaty and the subsequent political and social integration introduced by the Treaty on the European Union, also known as the Maastricht Treaty. The Maastricht Treaty, or Treaty on European Union, which was signed in 1992, extended the scope of European integration beyond economic matters into areas of a more political and social character. It created a new organisation called the European Union, which effectively encompassed three separate areas of activity. The first area of activity of the newly established European Union was economic union. As we have seen, following the adoption of the Maastricht Treaty, the EEC continued to exist but was incorporated into newly created European Union, and its name was changed to the EC, or European Community. The second area of activity of the newly established European Union was common foreign and security policy. Member states under the EU increased the efforts at coordinating their individual foreign policies. And the final area of cooperation under the newly established European Union concerned police and judicial cooperation. Under this heading, member states agreed to begin taking measures to coordinate policy between them in areas such as money laundering, asylum and refugees, customs cooperation, etc. Now let's briefly look at the treaties that were adopted after the Maastricht Treaty. After the Maastricht Treaty, or Treaty on European Union, other treaties such as the Amsterdam, Nice and Lisbon treaties were signed, all of which extended the scope of the European Union, reforming its structure so as to allow for its increased membership. As we have seen, the Lisbon Treaty, also known as the Reform Treaty, amended the TEU, the Maastricht Treaty, and replaced the EC Treaty with the TFEU, Treaty on the Functioning of European Union Treaty, thereby officially bringing the EC to an end. The Lisbon Treaty also further extended the role of QMV, qualified majority voting, and the role of the European Parliament as regards the adoption of legislation. It created a new position, the High Representative of the Union for Foreign Affairs and Security Policy, in a bid to better coordinate EU member state foreign policy. Finally, in recognition of increasing EU unpopularity, it put in place, for the first time, a procedure whereby member states can leave the EU. Let's take a look at the institutions making up the European Union. In order to achieve its aims, the Union has created a number of different institutions. The first is the European Council, composed of the heads of state of each of the member states. The European Council became a formal institution of the European Union pursuant to the reform introduced by the Lisbon Treaty that was adopted in 2009. The European Council has the power to introduce policy and generally gives political direction to the European Union. The second institution is the Council of the European Union. The Council, along with the European Parliament, is the dominant legislative power of the EU and is composed of ministers from each of the member states. The third institution is the European Parliament. The European Parliament represents the democratic face of the European Union and is elected by direct vote of the Union's citizens. The Parliament is the second member of the Union's two-tier legislative structure. Thereafter, there is the European Commission. If the Council and the Parliament represent the legislative power of the Union, the Commission can be considered to act as its executive branch. As the Union's executive power, the Commission is responsible for proposing EU laws that are later adopted or rejected by the Council and the Parliament. Then there is the European Central Bank. The European Central Bank, or the ECB, also became an official institution of the European Union pursuant to the terms of the Lisbon Treaty in 2009. Its function is to govern the EU's single currency, the euro, made up of 19 of the 28 EU member states. And finally, there is the Court of Justice of the European Union. The Court of Justice of the European Union is responsible for the application of the treaties making up the EU, as well as the laws and decisions adopted thereunder. The judicial branch is made up of the General Court, a civil service tribunal ruling on staff disputes within the organisation's institutions, and the Court of Justice. The Court of Justice has both appellate and original first instance jurisdiction. The European Union now comprises 28 member states, all working together in the areas of activity outlined above. It is a major economic superpower which has allowed the countries of Western Europe to overcome the economic hardships of war, and it has also facilitated the peaceful transformation of Central European countries into modern European economies founded upon democratic values. We hope you enjoyed this introduction to the European Union.